Good afternoon and welcome to The Appeal Live, a co-production of Now This and The Appeal. I'm Emily Galvin Almanza. So for decades, it has felt like we are living in Dick Wolf's America. Shows like his Law and Order franchise, endlessly on television, steeped Americans in this vision of police and prosecutors as heroic public servants. But in recent years, more and more people have found themselves waking up to the reality that hyper-policed Black and brown Americans knew all along, that the justice system is a really long way from justice. This has manifested itself in obvious ways. We are all aware of the uprisings for racial justice and social justice that took place across the country last year. But it seems like our collective awakening has recently rounded new corners too, as certain prosecution industry groups have been revealed as corrupt and self-serving. And this, in turn, has shifted the way some voters are reacting to prosecutors who abuse the public trust. Now, in California, the California District Attorneys Association was, until recently, a little-known group that spent much of its time lobbying against criminal justice reform in Sacramento. But in January, an audit revealed that the CDAA had been misusing certain funds, repurposing them for its own ends. The group had been given money that was specially intended to protect Californians from toxic environmental crimes. But instead of using that money to do what it was for, to protect its intended beneficiaries, it used those public resources for its own lobbying and training. So between this scandal and the quite notable departure of Los Angeles County District Attorney George Gascon from the CDAA last month, voters are beginning to have questions about the CDAA's way of conducting business. These numbers, I'm going to tell you right now, come from a recent poll conducted by Data for Progress and The Appeal. So once voters were informed of these audit findings, informed of the audit that had shown the CDAA had reappropriated environmental crime money for its own lobbying, 58% of voters, and interestingly, including 62% of Republicans, said that they found the CDAA either not very or not at all trustworthy. 46% of voters, again, including a higher proportion of Republicans, 53% of Republicans, said that they would be less likely to support a policy if the CDAA is in favor of it, compared to just 19% who said that the CDAA's policy endorsement would make their own support more likely. And these numbers held across the board, including a broad Republican majority who thought that the CDAA was acting in a manner that was self-serving. So here now to discuss this new polling and how voters feel about this group and prosecutors more broadly is Miriam Krinsky, the Executive Director of Fair and Just Prosecution, a group that works with newly elected prosecutors to work toward building a fairer and more fiscally responsible justice system, and Tyler Yeargain, the Associate Director at the Yale Center for Environmental Law and Policy. Both of you, thank you so much for joining me today.
Of course, thank you for having us.
So Miriam, I want to start with you to just give us some background. Like, in an ideal world, what would a prosecutor's professional association actually do? And has the CDAA done that?
So I think, Emily, with thanks for your interest in the issue and the coverage of it, I think ideally a prosecutor's association would recognize this different moment that we're in, that the Dick Wolf's America, as you put it, is no longer what voters and communities want, that there is no longer a view that the singular response to individuals who are struggling with poverty and with mental illness and with substance use disorder should be our criminal legal system or law and order. I think associations need to realize what the polling showed, that voters want accountability. They want associations that are honestly serving as stewards of the resources for those groups, but they also, most importantly, want associations that align with this new generation of leaders who are being elected in increasing numbers and who are realizing that we need to shrink the size of the criminal legal system, that decades-long sentences, mandatory minimums, 3 strikes enhancements, treating kids in an adult system, sanctioning a community that puts people to death, that no longer, in a bipartisan way, is what voters and communities want. They want change, and these associations need to align with that new vision of the justice system that our communities are demanding.
So I'm interested to hear you talking about community demand. And now we're going to drill down on the degree to which the elected nature of prosecutors ties them to the will of the voters. But just to confirm, it sounds to me like a lot of the things you listed, treating kids like kids, recognizing that substance use disorders are a medical problem, not allowing the state to kill its citizens. Like these are things that the CDAA seems to traditionally lobby against. Are you saying that their own lobbying has contravened what is the future of justice?
The future of justice and the will of that community. You reflected in the poll the lack of trust in that association in CDAA. That's really reflective of a broader problem where individuals in our society don't trust the justice system. They don't trust law enforcement. They don't trust the individuals who we give a gun and badge, and we need to trust to keep ourselves safe. So if we've lost that bond of trust, we have to think about how we rebuild it. And sadly, for decades, the CDAA has steadfastly stood against criminal justice reform. And they're not alone in that regard. They're one of many associations around the nation who have stood against change and who in increasing numbers are failing to align with what communities understand and what data tells us. We're alone in the world in the incarceration rate in this nation. And we need to move forward in a direction that aligns with science and that aligns with what our citizens want.
So Tyler, I want to bring you in, and I'm gonna kick off our conversation by admitting something totally embarrassing, because I am a lawyer and I should probably be less driven by American cinema than this. But when I first heard about this audit, my first thought was the movie Aaron Brockovich, and I was picturing, the families in that movie whose lives whose lives were destroyed and sometimes taken by the impact of environmental crime. But my background is as a public defender, right? So my experience, I've never defended someone on a toxic crime case because my clients were not wealthy enough to be committing toxic crimes. But I'm wondering, we're living in this world where people are so familiar with my side of criminal justice, with the sort of petty racist impact of that system. But I'm wondering if you could kind of unpack for our viewers what we're talking about when we talk about environmental crime prosecution, what this money was supposed to be used for. What is that? And how do ordinary families experience the impact of that?
Yeah, so under California law, there's money that's given by the state to the CDAA specifically to provide support for prosecutors around the state that are launching these environmental prosecutions. And at its biggest, an environmental crime might be, the issue that PG&E, the main utility company in California, had a few years ago, when its negligence resulted in the 2018 California wildfires. Now, PG&E was criminally prosecuted. They only ended up facing a few $1 million in crimes, but they were prosecuted and it went through the system that way. But most environmental crimes are not really of that magnitude, at least the ones that are criminally prosecuted. Most of those are things like illegal dumping or excess emissions or something like that, operating within the regulatory scheme that exists both at the federal level and at the state and local level, where if there's a violation of what a company is allowed to do under those environmental laws, depending on the context, depending on the severity, and depending on the intent or the negligence of the actor in question, they can be criminally prosecuted. And the reality of it is that, a challenge of environmental prosecution is that it does transcend boundaries. If you own and operate a factory in San Diego County that is illegally emitting more mercury emissions than it's allowed to because the scrubbers in its smokestacks aren't working properly, that's not just going to stay in San Diego. The externalities of that are going to be felt all over the state and indeed probably all over the country to some extent. So you are truly affected by environmental crimes and environmental violations that happen anywhere else in the country because of the interconnected nature of our society.
It's funny, you got me thinking about the jet stream, that things that go into the air in California may totally end up in my backyard in Massachusetts. But I want to drill down for a second on the money aspect here, because I think it's also not obvious to people what the money is for. When we say the money is for prosecuting environmental crimes, you just mentioned severity of the dumping. Let's say somebody's dumping waste in a way that is going to contaminate an environment. You used San Diego, so let's use San Diego. in order for a prosecutor to explain that to a jury, what the chemical is that's being dumped, what impact it has on the environment, like why these fish have two heads, all of that strikes me as a lawyer like something that you really need an expert to unpack. So can you talk about, like, if I'm a prosecutor and I'm thinking about prosecuting a toxic dumper in San Diego, and I'm thinking about either doing it with money in my pocket or with no money for experts, no money for any investigation of, no extra money. How does that impact my prosecutorial choices? And what does that do to families who have experienced the impact of these crimes?
Well, the reality is that very few of these environmental prosecutions actually end up going to trial. And indeed, when we think about environmental prosecution, to some extent that's misleading. Environmental litigation happens all the time. The state attorney general, the US Department of Justice, or even, yes, a district attorney could very well go after a polluter in civil litigation, that is, that they're suing them. They're trying to get an order that the company agrees to not do that anymore. Actually taking it to trial in a criminal context and prosecuting is something that they generally don't do terribly often. And you identified one of the reasons. It's both technically difficult to do because you do need experts, and it's expensive. These companies can afford to hire some of the best lawyers in the country. And while it's very clearly the case that also some of the best lawyers in the country are working in prosecutors' offices, frequently I think that they are outmanned and outgunned, which is where the funding for the CDAA to come in and assist with those kinds of prosecutions ends up mattering a great deal. The reality is that if you're in San Diego County or LA County or a big county in California, or indeed elsewhere in the country, you may well have the resources. Not many offices have people who are specifically dedicated to environmental prosecution, for example. It usually falls under economic crimes divisions, for example. But if you're in a smaller county and there's a big environmental issue that's happening there, and you have maybe a few thousand people in your county, a few tens of thousands of people in your county, you probably don't have the financial resources to step up and prosecute it yourself. That's where the CDAA was supposed to step in. It was supposed to take the funds from the state, provide expertise, link prosecutors together, build sort of these information sharing networks and these support systems around the state. It's a good goal because, as I said, these problems affect multiple counties, multiple jurisdictions, and they extend beyond state boundaries even. And so it is something where there's some sort of collective action that's needed. And the fact that it was misusing the funds, the fact that it was using the funds to lobby the legislature for more punitive legislation instead of actually supporting prosecutors around the state should give prosecutors in California serious doubt about whether their time and energy is best spent as a member of the CDAA or not.
That's such an interesting point, and it actually hadn't occurred to me until just now. A lot of the lobbying they were doing was arguably against equity, right? These reforms are designed to create a more equitable system in which Black and brown people are less burdened by unjust enforcement. And it's funny because to fund anti-equity lobbying, they were actually harming equity in the environmental law context, where the funds were intended to create equity for prosecutors to have the means to fight the big guy companies who might be committing some of these toxic crimes. So Miriam, I want to come back to you to sort of drill down on the prosecutors and voters relationship here, because obviously prosecutors are elected. So it is bad that voters are saying that their primary association in the state seems self-serving and, perhaps untrustworthy. I was really, really surprised, though, to read more reactions. I was reading, it's online, I'm on Twitter, and I saw that Carissa Byrne-Hessek, who leads the Prosecutors and Politics Project at the University of North Carolina School of Law, wrote that from 2015 to 2018, criminal justice-related bills in California were actually more likely to pass if prosecutors opposed them. In other words, it's good for reform for prosecutors to hate it. So I'm wondering if you can talk to us for a second about how you read that. Like, what does it mean to you about the future of prosecutors, criminal legal reform, and what's possible?
So it's interesting because we actually had Carissa come and talk to some elected prosecutors that we work with who are interested in moving reform on the flip side of that opposition that you referenced earlier. And we asked her to drill a little bit into that fascinating statistic. And her work is ongoing. And I don't think she necessarily yet fully understands that data point and what we can tease out of it. I think what we do know at a minimum is that prosecutor associations historically, for decades, and not just in California, have stood against reform. They have opposed the elimination or reform of mandatory minimums, of 3 strikes, here in California, of efforts to raise the age and not put 14 and 15-year-olds into the adult system, where we know inherently it's not just wrong for the individual, it's wrong for the community. They will come out more at risk to our community. They've opposed things, as we referenced earlier, like elimination of the death penalty and so much more. We also know, when we look around the nation, that voters in increasing numbers support those reforms. We see it in Poland. We also see it in the initiatives that they're enacting, most recently in the last election, not simply through their election of reform-minded prosecutors and sheriffs, but also through their embracing of initiatives to reform how we think about drug policy, to reform police accountability. So we do know that prosecutor associations are at the opposite end of what voters are embracing and demanding. Now, how legislatures are processing that, I think it's not entirely clear, but we are seeing legislatures that are recognizing what the will of the people is, what their incumbents want, and also, as importantly as all of that, what data tells us works, how we avoid wasting money and wasting lives, how we avoid throwing people into a criminal legal system that in too many instances is taking a place that public health, that treatment, that substance use strategies, and so many other social supports should be filling instead. And I think the other thing that I want to reflect on in referencing some of Tyler's comments as well is that we also have to ask ourselves, what does it mean when associations whose members are ones who should be embracing and lifting up the rule of law are involved in misappropriation of money, are involved, as we saw a few years back in Florida and their association, with claims of plagiarism in a brief that they file in a court? What does it mean about those associations? And why are we investing? Why are elected DAs and prosecutors investing in institutions that are so far from where our communities want to see their justice system's North Star be? What does it mean? And why are we not trying to support alternatives to those associations, such as we see cropping up in California, in Virginia, and I predict over the coming years in other states as well?
Talk about those predictions for a second, because I'm sure that you and I are both totally aware of, like, there's probably thousands of 1Ls out there, first year law students, who think to themselves, I want to run for office someday. I want to be the next, great legislator, great lawmaker. I want this sort of national platform future. I have to be a prosecutor first, because there's this conception that there's a path from being a prosecutor to national office. We may or may not have a vice president who kind of supports that notion right now. So, but in a world where you've kind of described two camps, right? There's the will of the voters and prosecutors who are following the will of the voters towards a less carceral state. And then there's like these groups of regressive prosecutors who are clinging to the Dick Wolf world, the outmoded, 1980s, 1990s tough on crime way of doing things. And for a young person who's considering going into prosecution as a means of leveraging a political future, they're not going to have control necessarily over where they end up. So I'm wondering, as voters lose faith in regressive prosecutors and their groups, what ripple effects you see in terms of, that path? Is prosecution becoming less of a credential?
Hey, I think that those assumptions, those pathways, those presumptions are being completely blown out of the water. I think we've seen that over the last 4 years. We've seen it in the individuals who are making a very different path to the role of elected prosecutors. It used to be, even before, Emily, the pathway that you defined, that the presumption was to become an elected DA, you spent time in that office, you worked your way up in that office, and then you were almost essentially anointed. And once you had the job, you never lost the job. No one ran against an incumbent DA. And if anyone had the audacity to take on an incumbent DA, they simply never won. Well, that presumption has been completely debunked in the past few years. We are seeing individuals who are being elected as DAs who never spend a day in that job. We are seeing individuals take on incumbent DAs, such as we saw most recently in Los Angeles. And they're winning, as George Gascon evidenced in his election as district attorney in Los Angeles. And so I think when we play that out, inevitably what we're also going to see is the will of voters that are no longer believing that the pathway to elected office is to be a so-called tough on crime elected district attorney. And I think it's coming from philosophical choices that voters are making. I think it's coming from the realization, as I mentioned earlier, that we are an international outlier. I think it's coming from evidence and science, and it's bipartisan. I mean, the polling reflected that. This is not a singular side of the aisle embracing this claim. We are seeing individuals, fiscal conservatives and others, that want to stop wasting money. They want to stop wasting lives. They want to stop investing in a failed prison industry. So those changes inevitably are going to start to ripple up into higher office, just as we're seeing individuals in this past national election cycle espousing the vision of a criminal legal system that is fundamentally different than what people were talking about, even as recently as 4 years ago or 8 years ago. So this is a new dawn, and I don't think it's going to be turned back.
Well, continuing down that path, Tyler, I want to turn back to you for a second, because exactly what Miriam's been talking about. I mean, Americans and American voters seem to be now quite certain that there are way too many people in prison, that the racial bias of the system is appalling, but there's this other issue at play here that's kind of been percolating throughout our conversation, and I want to address it head on. As a public defender, I have personally defended people who were accused of selling water bottles outside Yankee Stadium without the right licenses. And I've had to fight to keep someone out of a cage for selling water. Now, when I think about that and compare that to the fact that we're talking about people who could commit large scale environmental crimes that float beyond state borders and float across entire regions of our country and poison our world, impacting perhaps countless people. It's weird to me that those cases don't go to trial and are getting under-resourced, whereas the water bottle prosecution is very well resourced and very top of mind for a lot of these prosecutors. So I'm wondering if you could talk for a second about whether you think prosecution is the right tool to take on environmental crime, whether prosecution is doing a good job of curbing environmental crime, and also in the environmental crime context, to the extent that there are tools. You mentioned that these cases rarely go to trial, that they're usually resolved or settled, that there are other forms of litigation controlling this kind of misconduct. To what extent people who are thinking about prison abolition and ways to respond to harm that are not violent, that are not involving cages, what lessons we can take from the environmental crime context back to the individual context and what that means about new ideas and responses to harm.
Yeah, it's such an important question because I think it does get at the core of what we prosecute, why we prosecute, and how that plays a role in different substantive areas. If we're talking about somebody who deliberately engaged in a massive act of pollution that harmed people in a meaningful way, then sort of intuitively, prosecution makes sense, right? It's using the power of the state to, in some form or another, maybe avenge, maybe rectify a wrong. But at the same time, if we are adopting sort of an abolitionist, decarceral point of view, we need to take a step back and think, are we just, doing what we want in this context without regard for the broader philosophical questions? The reason that it's difficult to take environmental crimes to trial and to prosecute them criminally is, as I mentioned, because of the resistance that's there, that it's people who are able to hire the best possible defense attorneys at the highest possible cost. They're able to gum up the legal system. And you have to think, why is that not happening in everyday criminal prosecution? Well, in large part, it's because guilty pleas are normal. People plea bargain out of crimes all the time. And as Michelle Alexander has written, if everybody truly went to trial, then the entire criminal justice system would totally break down in an instant, because that's not how it's built. It's built to have people plea out and go to jail, sometimes for crimes that they didn't commit. And so as we're talking about environmental prosecution, I think a lot of the lessons are replicable. But we also have to take a step back and think, if we're pursuing a multi-million-dollar, civil penalty against someone, what's the equivalent of that at the local level? What's the equivalent of that in a crime where, as you mentioned, there is no victim? If we're talking about somebody who committed wire fraud, a civil penalty to assess to something like that, to some extent, I think that's an empirical question. But I do think that it's a valid way of looking at it, that the same reasons why it's difficult to pursue environmental crimes from a prosecution standpoint should be the same reason that it should be difficult to pursue lower level crimes. There should be that resistance. It should be something where cases are fought. There is no trial penalty. There's nothing like that. And people are actually able to put on the best possible defense, take their cases to trial, and get some sort of verdict. And if that means that we have to reimagine a little bit how our system is oriented, then I think that makes sense.
Well, Tyler and Miriam, thank you both so much for joining this. This conversation was completely fascinating, and I feel like I learned a ton. So I hope those of you watching did too. I look forward to hopefully seeing you both back here again soon.
Thank you so much. It was great to be here.
So as a longtime public defender, I often doubt my own gut reactions when I hear about various forms of prosecutorial misconduct, because my own gut reactions tend to be pretty negative. When I hear about people ignoring an oath they took to protect the public, it strikes me as appalling, especially when we're talking about harm as serious as a toxic crime that could damage thousands of people, thousands of families, land irreparably. But what's really interesting is the polling we've talked about today and the perspectives we just heard from our guests are starting to show this incredible groundswell of change. Voters, including voters who are politically disaligned with each other, are coming to an agreement that prosecutors funding regressive lobbying at the expense of protecting actual people from harm is no longer okay. It's no longer going to be overlooked. This is a changing view in America, where for so long police and prosecutors could do no wrong. Even voters who may not be on the defund the police train are looking at this action in the California DA's Association and thinking that it is untrustworthy, thinking that they are no longer to be trusted with the future of what justice should look like in that state. And perhaps that echo effect is being felt more broadly, as Miriam described, across the nation. There's a strong lingering question here, though, that Tyler Yeargain just raised, which is the equity question, right? Why are these groups so willing to fight to keep putting individuals, and we're really talking about low-income Black and brown individuals, in cages for crimes that are dramatically less serious than poisoning an entire county or beyond? Why sacrifice large-scale harm just because it's harder to fight against, well-paid fancy lawyers? The fact that they are willing to sacrifice that opportunity to do justice and to protect people in favor of this regressive, harmful, oppressive view of what justice should be is deeply troubling. And apparently, it seems like it's troubling the voters as well, and they may have had enough. We will find out soon enough, as there are many prosecutorial races we're going to be watching in 2022, as soon as next year in California. I can think of a few off the top of my head: Alameda County, Santa Clara, Riverside. We will be watching it all for you and with you. You can come back here for all the news. You can follow The Appeal on Facebook or Twitter. I'm Emily Galvan-Almanza, and this has been The Appeal Live.